Okay, I will call the meeting of the Rules Committee to order. And before we start, I just want to thank no, don't leave. I want to thank you. I wanted to thank our Dave and Sean from our IT department and everybody who's helped launch our maiden voyage of doing a hybrid meeting of the Rules Committee. I think they thought I was crazy when I said this, but I do want to appreciate it. Thank you for your assistance. I think we're all set though, unless you want to hang out.
I can move the microphone.
I probably know the microphone.
Yeah, okay.
No one's gonna sit down. So.
Thank you. All right. The first item on our agenda is the approval of the minutes from the October 17th, 2022 meeting of the Rules Committee. Is there a motion to approve? Been moved. Is there a second?
Second.
So been moved and seconded. Are there any changes or additions to the minutes?
There are, Your Honor. I have two, I believe. First is, they're both technical. First one is on page 2. You had asked that the Court Reporters Association be contacted for 2022-11, and it says in there Court Reporters Office, but I will change that to Association. And on page 3, 3 in Appendix A, page 3 of Appendix A. Technically, the Reporter's Office is going to a different system of addressing or identifying email. They don't use a hyphen anymore. So I need to take that hyphen out and put it back to just email.
Welcome to my life. This is what they do.
Yes. So those changes will be made.
All right. With those changes, is there a motion? We've moved it and seconded it. All in favor, say aye.
Aye.
Opposed, say no. Opposed, say no. That passes unanimously. I should have, for the record, let's do the attendance. Sorry.
Okay. Your Honor is here. Judge Chaplin. Here. Judge Hernandez. Judge McLaughlin.
Here.
Judge Gwen O'Dowd.
Here.
Judge Pearson.
Here.
Judge Prats.
Here.
Judge Stewart.
Here.
Thank you.
Quality of the sound is
I think
excellent.
I'm off the committee.
Judge Farley's here.
Oh, I'm sorry, Your Honor. Judge Farley. I
You're
checked
rating
you off.
candidate today.
I saw you and checked you.
Okay.
Farley is here.
All right. So the next item on the agenda is the proposal 2022-006, proposal concerning Rule 2.11 of the Code of Judicial Conduct. Oh, okay. That's me. We held this last month because I needed to talk to Judge Prescott and Justice Doria about what the Appellate Rules Committee is doing, not with respect to anything that would impact us, but it was actually the substance of it in the appellate system. And so they've addressed my concerns about the substance of it. So I didn't see any impediment for us to move forward with this proposal at this time, but we'll open up the floor to any discussion.
Well, I was wondering, should we be waiting to vote on it until after?
They're waiting for us.
They're waiting.
We talked about this.
Yeah.
I can't, it was a nuanced argument that only, people up in the high in the sky theoreticians would want, but they think that they need to conform to us because it really doesn't matter because
No.
they're going to do it. None of it's going to take effect until we vote on it. And I think we both have the same effective date, which would be October 1st. Is that right?
That could be if you want that.
So it doesn't, in substance, it doesn't matter who goes first. They'll both be springing forward at the same time on October 1st. Anything else? Right? Is there a motion to approve?
So moved.
Is there a second?
Second.
Any further discussion? If not, all in favor, say aye.
Aye.
Aye. Aye.
Opposed, say no. That passes unanimously.
That, Your Honor, you will have to recommend to the judges that it be adopted on an expedited basis for the 10/1
Okay.
date.
Why would it?
January 1st is normal. And
Well, then let's check. They didn't make me think it was going to be any different, that it was going to happen at the same time. So maybe I just assumed it was October 1st. Maybe you can check with Judge Prescott.
Okay.
I'm here, and
Oh, there you are.
January 1st, 2023 is would be 2024, right?
23.
23.
23.
No, 24. You're right. You're right.
Right.
Oh yeah, 24.
Yeah.
My-
Why we weren't math majors.
No, we don't need it. We don't need it for October 1st.
Okay. Okay, great. And thank you for your meeting with me and clearing up my problems.
No
Well, at
worries.
least some of my problems, Judge.
Okay, thank you.
So the next item is 2022-010, proposal to amend practice book section 7-11, allow civil protection orders to be retained for 5 years as opposed to current 10 years.
That was on the agenda for September. It was a proposal from Judge Abrams when he was the chief administrative judge in civil. In September, it was, well, at that time, I believe Judge Bellis became chief administrative judge for civil, and she is now, and that was referred to her. She has comments in the package. It was also referred at that time to the Office of Victim Services, Judicial Branch Office of Victim Services, and the Office of Victim Advocate. You have comments from the Office of Victim Services. Neither Judge Bellis nor Victim Services opposes this. The Office of the Victim Advocate has not responded to the referral.
Okay,
Excuse me, I'm sorry to interrupt.
sure.
Got a notification from Carolina that the screen was frozen on their side, so I just wanted to chime in and see if Carolina, can you see if the screen is still frozen?
It's unfrozen now. Thank you so much.
Okay,
Thank
Very
you.
good.
Thank you, Sean.
You're welcome.
Okay, so everybody's on board. Is there any discussion? Seeing none, is there a motion to approve?
So move.
Is there a second?
Second.
It's been moved and seconded. Seeing no further discussion, all in favor say aye.
Aye.
Opposed say no. That passes unanimously. Next on the agenda is, I'm sorry, what is this? 11. 2022-011, the proposal to amend the practice book to eliminate the requirement for original printed deposition transcripts. Joe?
Yes, this went to the Connecticut Court Reporters Association. That was two-pronged. One of the proposals went back to Attorney Goodbaum for further investigation. This one, the original printed depositions, there's comments in the file from Judge Bellis. You referred it to the Connecticut Court Reporters Association. There are two individuals here on screen from that association, Christine Mannix, who's the president, and I believe Lisa Graziano, who's the vice president. They did submit some written materials, but they are here to address the committee's concerns.
Good afternoon. And I see Attorney Goodbaum as well. Who's the designated speaker on behalf of the court reporters?
I am, Your Honor. Thank you very much. Good afternoon, members of the Rules Committee. My name is Christine Mannix. I'm the president of the Connecticut Court Reporters Association. Also present with me today is our vice president, Lisa Graziano. Thank you for allowing us to present for your meeting today and for seeking our input regarding the proposal to amend Practice Book Section 13-30E to eliminate the requirement for original printed transcripts. Your email specifically requested our input on whether electronic versions of a transcript can be watermarked or otherwise verified, thereby eliminating the need for original printed transcripts. This issue was discussed at our board meeting last week. Most court reporting software these days does have a watermark feature. There is also the ability to place a header or a footer on the transcript, which could display the word original on each page of the transcript. I do have a sample that has been emailed to you. It is item 2022-011E. If you can refer to that, please.
We have that. Thank you.
Thank you so much. These are various watermark locations and a sample of a footer. This could also be placed at the top of a transcript, which would be much more easily viewable than a footer. This is a printed copy, but it will appear on the electronic PDF as well. One question our board did have was whether this proposed amendment would be an either-or situation. The wording we received said eliminate the requirement for an original printed transcript. As I said, not all reporters' software may be capable of producing this watermark. However, I reiterate, we believe the vast majority will be able to do so. Our hope would be that if this section is amended, that a printed original would still be an option for reporters who may not have software with that capability. We would be agreeable to doing further research if the options I presented do not meet with your satisfaction, and I'd be happy to answer any questions if you have them at this point.
Thank you. Are there any questions?
Yeah.
Judge Barlight.
I'm looking at what I'm wondering is whether any of these approaches would be something that somebody could duplicate. Somebody with a copy of the transcript, would they be able to go in and, for example, put an original header on the transcript in the form in which they received it, and then somehow that be presented as an original transcript?
That is a very good question that I do not know the answer to, because that would be a PDF version of the transcript that they would have received, not with our watermark. I can research that further. There probably are options in a PDF to insert a watermark, but I do not know the answer to that. I would not be able to get that from my software manufacturer. That would probably be something that would take further investigation into the PDF software. I don't believe anybody can edit my PDF once I send it, but I have not tried that. I'd be glad to send a PDF if someone wants to try to edit it and see if they can do so.
You can edit some PDFs. Maybe we should look into this. And there are security features to prevent any editing of a PDF, but I'm not savvy enough to know what they are.
Nor am I. But I would be glad to research that, though. I can call my software company and they might know the answer to that, or we can research that, in greater detail if this is something that we would like to do. I just am hoping, though, this is an either or option, though, because there are some court reporters, as I said, who may not be able to do that.
Okay. We're not taking any action today. We're going to need you to do that. So let me ask if there's any further questions that we need to have addressed for us to have this come back. Judge Chapman?
Just one question regarding the court reporters who may not have the software. Is that a minority of those or majority of those?
I would say that's a vast minority.
Okay.
Distinct minority, yeah. My own view would be you'd want whatever you used to appear on every page of the deposition.
Yeah.
So like the ones with the original stamped across the middle, that would be annoying to read a deposition with that on every page. But if you had it as a header.
Right now, I'm sorry to interrupt, isn't it just stamped on the first page?
Yeah.
Correct.
Yeah, but I'm not sure that works as well if you're dealing with electronic.
It is not, if I may interrupt, Your Honor, it is not just on the first page. I just made up a sample for you that was just a one page.
Yeah.
It does appear on every page of the transcript. There are options, though, within at least my particular software where you can make that watermark very, very faint. I think that was the second to lightest, and then maybe one of them is medium. One of them is very faint. You could read through that one. And you can place it on different spots, but it does go throughout the transcript, also in the PDF version.
So forgive me then, if you can move the watermark. If you can move the watermark, could you put it in the header?
On my particular software, I was unable to move the watermark. The only way you can have it is from bottom left to upper right or vice versa, or across the middle of the page. I would have to investigate that further with my software. It did not give me any other options. The other option was if you looked at one of the pages that said original on the bottom, that's called a footer. That's normally where someone would put the name of the court reporting agency. So I would recommend more so if we were going to do that, that you could put it as a header, which would be at the top. That would not block any prints at all. However, it's not very big. It would just say the wording. If you look on one of those examples I gave you, it says original spread centered on the bottom of the page. That could be put on the top of the page. I'm sorry I wasn't able to do that today. I am on vacation, so I was trying to work with the setup that I have, the remote setup I have in Florida.
Well, first of all, let me thank you then for interrupting your vacation to participate in this meeting.
No, thank you for letting us join. We really appreciate the, working together on this.
So, yeah, I mean, I don't feel strongly, but I don't deal with these, so I don't feel strongly about it. Good, sir.
I would avoid the footer for sure, because that's where people typically stick the exhibit sticker. And also oftentimes there's base numbers. If those are involved, those are typically in a footer location. Otherwise, I don't feel strongly about whether it's in the middle of the page or up at the top.
It would look very different though, because that's the one that would be at the top of the page that you see on the bottom of the page right now. That is called a header. That is not a watermark. So that's the only distinction I would make. Mm-hmm.
Yeah.
And would the header be in color or normal print color, black?
No, I don't believe that there is an option to do that. I mean, I can research that. I'm writing this all down so I can ask my software company, but there are probably 5 major court reporting software companies, so they may all be a little different. If this does go and pass, then we can work together to disseminate this information to our members and work at getting, what would work for you.
Okay. So I know Attorney Goodbound wants to ask a question, but let me first see if any members of the committee have any further questions first.
Can I just ask,
Yep.
so when you do can you do both? So could you do a watermark over the first page of the deposition, sort of, as you say, on the diagonal, and then all the other pages just put the header, or does it have to go throughout the entire deposition?
I am unsure on that. When I did try to apply the watermark, it did go on every single page.
Okay.
So it did not give me an option to do something other than that. I can check, but I would believe that you would not be able to do that.
Okay, thank
You
you.
could probably put both, the header but you wouldn't be able to take it only on the first page, as far as I know.
Yeah, no, I was thinking, because then at least on the first page, everybody knows in their files and everywhere else, the first page has got the original across, but then to make sure it doesn't interfere with being able to read it, putting it up top, but I could see that would be difficult.
Mm-hmm.
Okay. Any other questions from members of the committee? If not, Attorney Goodbound?
Thank you, Justice McDonald. May I make a brief comment?
Sure.
I appreciate Judge Farley's question about security. I suppose I'm not sure I understand how that connects up with what our current practice is. So our current practice in the state courts is that a court reporter will take, will attend a deposition, write down everything everybody says, generate a transcript, and send copies of that transcript out. For the lawyer who takes the deposition, they get 2 copies. They get their working copy and they get their original copy. And the original copy is in a sealed envelope, though frankly the glue is not very strong and it's really easy to open the envelope and then reseal it. Ultimately it is, and the only difference between the original and the copy, the working copy that you get, is it has a red stamp on the front that says original, the kind of stamp that anybody could buy for $1 at any convenient, office supply store. Ultimately, what keeps us from faking transcripts is our ethical obligations to the court. And of course, it's the wrong thing to do. And none of this comes up in federal court. So I suppose that Judge Farley's question and the questions of the other members of the committee have been focused on, well, how do we have an original that's not printed? And my point is, I'm not sure the original makes sense. The original is the transcript that was generated by the court reporter and that is disseminated in equal versions to every lawyer who orders a copy of the transcript. And then when the parties ultimately come to trial, they all have the same transcript. They have copies of the same transcript. I've never had a situation, I assume that none of the members of the committee have ever had a situation where lawyers are looking at two different versions of the same transcript. And of course, if I wanted to alter a transcript using a PDF or printing and rewriting or cutting and pasting or, through a variety of ways, I could do that. That's not something I would do, of course, as an officer of the court. And I don't think any other officer of the court would, but it is not 1330E that keeps us from doing so. And so I'm not sure that we need original transcripts at all, but certainly I don't think we need them printed in a way that's wasting hundreds of thousands of pieces of paper every year.
So you make some good points. We are, of course, the land of steady habits, and we don't change too quickly on anything. That may come to pass. I think what we're suggesting is if we're going to make this migration, we should do it in as secure a fashion as possible, maybe making the system even better. But your larger point is a good one. I'm not certain why we have this bifurcated system anyway. The great reveal of the transcript in a trial. I've never seen the big shocking moment when the envelope gets ripped open, but you make a good point. But why don't we table this for now unless there are any more questions, and hopefully we can address them and have the answers from the software company next month. Or do we meet in December?
Yes.
Next month. And then we won't be interrupting any more of your vacation, hopefully.
Okay. Well, thank you so much for your time today. We really appreciate you again seeking us out so that we could work together on this matter. If I can be of further assistance, please do not hesitate to email me. My email is christinemannix06@gmail.com.
Thank you very much.
All right. Thank you so much. Have a great day.
All right.
Thank you.
Next is 2022-015. Proposal to amend practice book section 7-19 to make clear that the judge may conduct an ex parte review, but also has the option to have the application filed in the official in this. Oh, okay. I remember this. Sorry. I got shot out of a cannon today. I apologize. Joe.
This was on September. It was a proposal from Judge Bellis. There was some discussion and some questions of the members. Judge Farley, I believe, headed a working group of this committee, and we'll report out on the progress or the status of the revision of that.
Yeah, we did collaborate, our working group, on a revised rule, and also consulted with Judge Bellis about it, and she is satisfied with what we've drafted. But toward the end of the process, it was suggested that we run the rule as we have drafted it past Judge Albus, who, as it turns out, was away and just returned today. So we have a draft rule. I expect Judge Albus will be on board. He agreed with the concept originally. So we have the work all done. Once we hear from Judge Albus, we'd be ready to vote on it probably at the December meeting.
Okay.
I'll just amend that. I'm the one that suggested that we should run it by Judge Albus, and that's just because he's Chief Administrative Judge of Family. And frankly, in my experience, there's way more of these self-represented party subpoenas in family court than are in civil court.
All right. So we'll revisit this next month. Next is 2022-017, proposal to adopt a new rule regarding the transfer of in-camera records from the Freedom of Information Commission to the trial court and administrative appeals of FOIC decisions.
Yes, Your Honor. This was on the agenda for October. It was put over to November to allow Attorney Murphy, who's the Executive Director and General Counsel of the Freedom of Information Committee, to address and comment, to address the committee. She is here today.
Yeah, sure. Come sit at the table, Colleen. Good to see you.
Considering the way the camera should go
like this side?
Oh, yeah, that's right. See? Always thinking, yes.
I do have some prepared remarks on this little bit of an oddball proposal, but Good afternoon, Chairman McDonald and members of the Rules Committee. Thank you for the opportunity to speak about the proposed practice book rule that we have presented. The Commission believes it's identified an area where the existing rules governing the sealing of court records are not a good fit. As you are likely aware, the practice book provisions regarding sealing of court records were modified a decade or more ago in order to ensure transparency and appropriate oversight over the court's sealing processes. Under existing rules, when there is an administrative appeal of a FOI Commission decision involving government records that were submitted in accordance with the Commission's in-camera procedures, the appealing party at the Commission or the Commission itself must file a motion to seal such records under Practice Book 7-4B and then lodge the records with the court pursuant to 7-4C. The moving party is then compelled to explain the reasons why the records that were at issue before the Commission ought to be sealed. In some instances, the trial court has ordered the Commission rather than the appellant generator of the records to file the motion to seal and lodge the records, conceivably because the Commission then has possession of these records since it adjudicated whether they ought to be disclosed or not. So the procedure in this context is cumbersome and problematic. The reasons why the practice book rules were modified aren't applicable in these situations. Moreover, in instances where the Commission is ordered to file a motion to seal, it is placed in a really odd position. The Commission isn't the keeper of the records or the party with an interest in confidentiality. Rather, it's the adjudicator that ruled whether the records must be disclosed to the public pursuant to the FOI Act. In this context, it is the agency that generated the records and it's declining to disclose them along with the person or entity who's seeking disclosure who are the interested parties to the action. So as you can imagine, the current procedure is particularly unusual in situations where the Commission has ordered disclosure. It's determined that the records ought to be made public, but there's an appeal ensues. And so then the Commission is in the position of trying to explain why records ought to be sealed when it has actually ordered them disclosed. So that's why I say it's an oddball situation just from a public policy standpoint, but also in terms of the particulars. Prior to those practice rule changes, we followed our regulations, which are now very much out of sync with the practice book, which isn't the main problem, but we would simply file the in-camera records separately with the court. We would notify the other side. The other side would file a motion to seal. The party seeking to not disclose the records would file that motion, and then the court would simply rule on it without a hearing, but just understanding the nature of the situation. So the practice book rule we propose would in these circumstances allow the Commission to simply lodge the in-camera records with the trial court apart from the rest of the public administrative record and remove any requirements and processes for sealing, which in this context we don't believe are necessary. In addition, although this revision to the practice book would apply to the FOI Commission, we can foresee it may have utility for other administrative agencies. We thought of DCF and consult, frankly, with one of the former administrative appeals. The judge who headed the administrative appeals area for a while suggested that maybe DCF and other agencies who are possess records that are confidential by statute should not have to go through this sealing procedure as well. So we tried to think of stakeholders who might have an interest in this other than ourselves. We reached out to the Office of the Attorney General as a potential stakeholder relative to other agencies to solicit any feedback or any opposition. And we received word back that there was no objection to it. In closing, the Commission believes that it has identified a need for modification to the current practice book rules, and that such a modification will simply simplify the administrative appeals process in a practical and logical manner. So I thank you for your time, and I'm happy to walk you through our draft or answer any questions you may have.
Well, thank you for that, and for also reaching out to others. So I just want to make sure I understand this correctly. The proposal, you don't want to be caught in the odd position of trying to keep something sealed that you said should be disclosed. I get that. I see it more as just sort of a stay of the whole thing until such time as there's an adjudication in court about the decision by the FOIC. So this doesn't seem like that's that big. You just don't want to be in a position of having to file a motion to have it sealed.
Right.
It's counterintuitive to your mission.
Right.
Okay.
Setting forth the reasons justifying, which is.
You would essentially flip it and say, here it is, let somebody move to unseal it.
Right.
Right? Okay. Other questions? Concerns? I haven't really thought this all the way through, but at least now I understand the problem.
Well, but if it's extended to other agencies, it could well be the agency that wants to maintain the confidentiality of a document. But I don't see where that really matters, though. If you look at it as a stay, what was sealed at that level is filed, and the record is filed with that portion under seal. That makes sense to me. It's just common sense, I think. But one question I had was in subparagraph E of the proposed rule, the suggestion is that after all appeals are exhausted and whatnot, that the lodged records be returned to the agency. I'm wondering why we wouldn't just treat them like any other sealed records. They're part of at that point, they're part of the judicial process.
Don't they all get returned?
What happens now? That was my question. So what happens now?
My impression is regardless of whether it's administrative appeal or whatever, if somebody lodges records with the court, they ultimately get returned.
If they've been
to whoever the party was.
Well, I don't know about that.
I don't know.
No.
I mean, I can tell you as a practical matter, that's what was happening in Bridgeport.
Well, the thing is that the order.
If there was no appeal and the stuff is just, because the clerk's office frankly doesn't want all that stuff sitting around.
In order to seal something the order can be modified, later.
Right, this was when the case was over and if no appeal was taken, the reality on the ground was the clerk's office was sending it back to whoever lodged it there in the first place.
Yeah, they used to hold on to it for a period of time.
What this is what I'm talking about, civil, criminal.
Civil.
I don't know,
Which is certainly what they're talking about for administrative appeals, that's.
And if I might, in our context, our regulations pick up following the ending of an appeal, and there's a process by which the records that were at issue, that if they were determined to be public, will be placed in our public file. And there's also a process by which the agency who originally submitted them to us shall come to us and retrieve them. I think that was understood that would generally be the practice, but that hasn't been happening. The court has not been returning those records to us. Sometimes we have parties come 10 years later and say, oh, could we have those records back now? And we've gone to the court and the court no longer has them either.
So some of them may be just chucking them, is what you're saying.
Right.
You said you reached out to the Attorney General's office. Do we know what they did to determine that they didn't have a problem with this? I mean, did they consult DCF?
Of that, I am not aware. My letter did go to the Attorney General.
I appreciate that. I don't know what.
Just heard back from somebody within his office.
Judge Nguyen might have some.
Do you have any insight?
With regards, I know in the past, we followed the practice book and we put them conditionally under seal. I know that this would make it easier for the office because almost all the records in the administrative appeal from the substantiation hearing are confidential. So the entire record would be put under seal.
And what happens at the end of the case? Are the records returned to DCF or?
That I don't know what happens at the end of I think it just stays, it stays with the court. I don't think it goes back to DCF.
Can we put this over for a month and can you talk to court operations? We just deal with the stuff on the front end. We don't deal with it on the back end.
Yeah. I'm kind of thinking like it's up to each individual JD. That sounds like.
All right. Well, we have Colleen here. Did anybody have any other questions on the proposal of her?
I have one. And this may just be hypothetical. But is there a need for language in the proposed rule to say that the general public shall not be able to review these items, that it shall only be disclosable to the parties of record, and that they shall not further disseminate them? The reason why I raise that is because in juvenile, those orders are standard. And that just came to mind because I didn't see that in there. I didn't want anyone to read the language of the proposed rule and try to rationalize that not being incorporated. It's like stating.
I'm sorry, can you say that again? I apologize.
So the rule as stated, just adding language to say that these records shall be confidential and shall only be viewed by court personnel, parties of record, and shall not be further disseminated without it. Just stating the obvious, so that way there is no mystery of statute.
Okay. Got it.
I think that's a good one. Not be opposed to that. It has never been an issue, to my knowledge. I don't think anybody's ever tried to access records in that way. I'm certainly not opposed to that concept.
Anything else for, I should say, Attorney Murphy? I've known you to say colleague. Okay, we're going to put this out over for until next month, so we can figure out what Court Ops does with it.
Do you want to send it anywhere else, Your Honor? You said Court Ops. Judge Bellis or Judge Cordani? I believe he's the presiding judge of.
In New Britain.
Yes. It's the first time being considered, so I asked because of that. I usually refer.
No, I appreciate that. Judge Bellis, she would normally send it to Cordani, but why don't we just send it to Cordani directly too? Okay. And Court Ops. Okay. Anybody else that you can think of? I think that's good.
Okay.
All right. Thank you very much.
Thank you so much. Thank you for the opportunity to appear in person too.
Always good to see you. Next is item 2022-019, proposal for various rules changes related to the Connecticut Bar Examining Committee's new online application process with applicant portal. This is the first time being considered by the committee.
Yes, Your Honor. The Bar Examining Committee launched the new website with an online application and applicant portal. We have Attorney Harrington here, who is the Deputy Director in Legal Services, and she's responsible for attorney services, and she can explain the full panoply of changes, I'm sure.
Good afternoon.
Good afternoon, Your Honor. How are you?
Good.
So thank you, Attorney Del Campo. I'm Kathy Harrington. I'm the Deputy Director of Attorney Services, and one of the offices that I oversee is the Bar Examining Committee. And as noted in the cover letter, the Bar Examining Committee recently launched the first part of its online application process and applicant portal, something we're very excited about. We're one of the last jurisdictions to try to become paperless. We've launched the application for the February 2023 bar application is online, and hopefully by the end of the year, we'll be online for all the rest of our applications for admission on motion, authorized house counsel, and so forth. So as part of this process, staff identified rules and regulations that would need to be updated and changed, and we brought those to the Bar Examining Committee, who approved the draft changes that we had. We've posted the regulation changes to go into effect in January, and now we're coming to the Rules Committee for a few changes, mainly on the admission on motion and military spouse provisions, where those had some duly verified language that would need to be changed. We sought legal counsel from Attorney Del Campo's office about how to have the application. It used to be sworn under oath, and now that it will be online, that's obviously not the way that it would be filed. And with their advice, we are making it all so that they are unsworn statements under the false statement of, under the penalty of false statement. And so these are the changes that we're looking to make, with a few other minor changes. For example, changing the name of the director from administrative director to director. And the director of the Bar Examining Committee, which is Lisa Valco, she's also on the call, so we are able to answer any questions that you all may have.
Questions? I frankly only perused this quickly. I'm being honest. I need to. A lot of it seemed technical, and I'm sure that Attorney Del Campo's office got it right. I'm going to want to look at this in a little bit more detail, but are there questions for Attorney Harrington?
One, there's, one of the changes appears to be more of a substantive change in 2-8, subparagraph 8, subparagraph C. If that paragraph is being deleted, which may be something that the committee wants to do, but it is more of a substantive change where this is the section deals with an alternative to the educational requirements. And I gather that right now it's required that the applicant intend to actively practice law in Connecticut, as their full-time employment, and that's being taken out. So what's the reason?
What's the rationale?
Thank you, Your Honor. I'm sorry, I just unmuted and remuted myself. I apologize. Thank you for pointing that out. I should have mentioned that. That is one substantive change that we are recommending, that the Bar Examining Committee is recommending. The motion rule used to have this intent requirement, and that was recently taken out by the Rules Committee, so that an applicant from another jurisdiction who's been licensed there for 5 of the last 10 years may apply now without the intent to practice here actively in the practice of law. And it made sense to the Bar Examining Committee that it should no longer be a requirement for someone under this provision. This would be someone who does not meet our traditional educational requirements and would be coming under the 2-88, which is another means for them to qualify to sit for the exam.
Okay. Okay. Other questions at this juncture? Again, this is the first time it's appearing on our agenda. Anybody that we would normally ask to see if they have comments on something like this? Can't.
I don't believe so.
There's no CBA section on professional standards, is there?
I mean, I suppose you could send it to the CBA if you like to see if they have any comments.
Yeah, why don't we just generically send it to Bill Chapman and he can determine whether or not they have anybody who cares.
I mean, they have the
Hi, Justice McDonald.
practice of law.
Yeah. Oh, who's there?
It's Melissa Biggs. I am taking over for Bill Chapman and monitoring these meetings. So I'm still new in this role, but I can send it out to see if anyone has any feedback.
Okay. Is Bill still with the CBA?
He actually retired in July.
Oh, I didn't get the memo. Okay.
It was not well broadcasted, so I apologize. But
I'm sorry, what's your name?
Melissa Biggs.
Okay, thank you very much for piping up. Yes, we don't know who would care at the CBA about this, but you can find that out for us if anybody cares.
Absolutely, will do.
Okay. Anybody else?
Grievance committee, they're the ones who would have to, I guess, pursue a violation of the rule if somebody was practicing. Not really, though.
No, this is for admission.
Well, this is Bar Examining.
Admission.
Yeah, I mean, it seems to me the only people who might care is the CBA Unauthorized Practice of Law Committee.
Yeah.
We won't care, but.
I didn't know they even had one.
Yeah, they do have one.
All right, that might be Melissa's go-to group. Okay, so we'll put this over. Why don't you just send it to Melissa, and I will have a chance to look at this in more detail. We'll take this up next month. Okay.
Thank you, Your Honor. We appreciate it.
Okay, I don't think there's anything else on our agenda.
No.
Anything we need to talk about, folks? Nice to see some of us in person. Yeah, it's been a long time since I've been in a meeting in this room, actually. All right. If there's nothing further, I'll accept a motion to adjourn. So it's been moved. Is there a second? Second. All in favor, say aye.
Aye.
Opposed, say no. That passes unanimously. Thanks, everybody who's joining us remotely. It's good to see you. Take care.
Thank you.